Hi, everyone. Welcome. Thank you so much for joining us today for our monthly Title IX team meetup, which is Title IX Education Administrators Meetup. Our team meetup is, for those who may not know, something that we started this summer to offer a place for administrators and practitioners of Title IX to come together to discuss questions arising in the field as they worked to implement the new Title IX regulations. And although we stopped our weekly team meetups after the August 14th implementation date of the new regulations, we heard from many of you that this was a valuable opportunity for you to think through Title IX issues with your peers and your forensic attorneys. So we're excited to be back on a monthly basis. We are meeting monthly on the first Tuesday of each month from 12:30 to 1 p.m. And we also heard from many of you this summer that you wish that these meetings would be recorded. And so we've switched over to a webinar format so that we can record and share these meetings. You can still ask questions using the Q&A function, including anonymously. So we hope that this will strike the balance between offering a safe place to ask questions with the need to make this programming accessible to you all considering your busy schedules. You should make sure to sign up for our alerts at Franczek PC at our website at franczek.com so that you receive notice of these team meetings going forward, as well as all of our other thought leadership and insights on both Title IX and a myriad of other education law issues. For those who don't know me, my name is Jacky Godapur-Werns. I'm a partner at Franczek, and you can find on the materials that you'll receive a copy of this PowerPoint in a PDF following today's meetup, and hopefully it will have live links that you can click through if you need to contact me by email. You can also find my Twitter account at Jacky Werns, or you can find me on LinkedIn. I do tend to share quite a bit of Title IX and other civil rights information, legal information through those resources. So please find me, seek me out, and follow me there. If you don't already know that we have a great Title IX website at Franczek, it's title9insights.com. And again, we have a link here for you at the top of this slide. Please check it out and sign up for reminders when we post new blog posts to that page as well. And as I mentioned, this is being recorded as we record almost all of our webinar content here at Franczek. You can find our recordings on our YouTube page. We have a YouTube channel for Franczek PC, and we have a specific channel for Title IX. And you also can always find, if you just look at our events page on our franczek.com website, you can always find there. If you look at past events, you can find those that have been recorded. You'll find the PowerPoints and the recordings on those pages as well. So today we wanted to style this as a Q&A, as an Ask Anything, and we really appreciate we received a ton of questions through those who registered. So thank you so much for sharing your questions with us. And you can also ask questions using the Q&A on Zoom, as I mentioned, and I'll do my best to try to get to all of the questions that are brought up today. So let's jump right in. I would say the biggest question that we receive is, or have received, is about, and I love this little clip from Hamilton, the King George. I could watch this over and over again. What comes next? From that great song in Hamilton. What comes next? Do you know how hard it is to lead? And I think that that is going to be a big question in the Title IX front, and that is shown by the questions that we have received today. So just to give you a flavor of the types of questions that we received, we had one commenter who said, I don't really have any pressing questions about Title IX, but The recent Franczek What Comes Next Q&A, our video podcast, was a great listen and really what has been the most on my mind as of late. We had another question about whether anyone has heard of the OCR pestering school districts about the new regulations, or is OCR intending to stand back until the Biden administration is on board? And then what are your thoughts on when the Biden administration will rescind the current Title IX regs and come out with new regulations and guidance? And if they do come out with guidance and those guidance documents conflict with the regs, which ones are we supposed to follow? So we do have a lot of resources available for you on that front. As I mentioned, we recently had a video podcast that was hosted by forensic attorney Kendra Yock, and was myself and Amy Dickerson and Emily Tulloch who were the guests on that program. And we talked all about all of the different options that might be available to the Biden administration. We know that Joe Biden, on the day that the regulations were released in May of 2020 in final form, Joe Biden came out and said that he intended to get rid of them if elected. But the question is how and how quickly will he be able to do that? And so we discussed that at length in our video podcast. We also covered it in a recent blog post, which will be linked on our slide as well. And also recently, I was very excited to be asked to be the first guest on a new podcast, Title IX and the Title IX and Civil Rights podcast, which is hosted by Dan Shore LLP, which is an investigations company out of New York. So we also had a really robust discussion about that as well. So all of those are great resources if you're looking for more, if you want to think more about how might the Biden administration get rid of these rules, what might that look like? What methods are available and how long might it take? But the short answer is that we don't have any reason to believe that this is going to be a quick turnaround. Because the Trump administration issued these regulations as administrative rules and not just as informal guidance, they have the weight of the law. And the way that they can be overturned generally is either by amending the law itself, which would supersede the regulation, or by passing a new regulation, which would require going through notice and comment, just like the Trump administration did here. And what we know is that that is a lengthy process. Even assuming the Biden administration hits the ground running with a rule that's ready to publish for comments, we would expect it to take at least 12 to 18 months from the date that the rules are published for them to be able to get through the entire process of reviewing comments, making any changes that are necessary, and getting that rule out in final form. So we do think the short takeaway is that you are going to need to live with these rules for some time. There is a chance that the Biden administration could try to, while it's in the process of changing the regulations, that they could issue guidance in just attempt to sort of modify the shape of the regulations. So give them a different color, a different reading. And that is a possibility, but it does create a little bit of a dilemma for educational institutions, to the extent that those were to change, were to say that you should do something different than what is in the regulations. So if the regulations say you should do X, Y, and Z, but the Biden administration's Department of Education comes out with guidance that says actually you can do A, B, and C, what they would be able to do is to tell schools, we won't try to take away your federal funding if you do A, B, and C instead of X, Y, and Z. And so if someone were to file a complaint with OCR, they would be saying, we will not enforce that rule against you to take away your federal funds. But the problem is that someone could file a lawsuit, probably a respondent who would be looking for more due process rights. than were provided previously under Obama era guidance and that are set forth in these regulations. And what that lawsuit would say is, we don't care if the Department of Education told you that you can do A, B, and C instead of X, Y, and Z. X, Y, and Z is the law of the land. And so you must do that. And they could go to a court and ask them to force a school, college, or university to do so. And so what we're hoping for from the Biden administration is that they don't give us something that will put educational institutions between the proverbial rock and a hard place, where they're having to decide what is the lesser or the greater of evils. Is it following these rules, even if the Biden administration says you don't have to in order to avoid a lawsuit? Or is it worth risking the potential of a lawsuit in order to not have to put into effect these burdensome rules? Right now, again, the takeaway is that you do need to continue living with these rules until we see what the Biden administration intends to do. And hopefully we'll get some clarification from them pretty early on about what their intentions are. But regardless, right now, you need to make sure that you are still complying with these new regulations for any complaint that is of Title IX sexual harassment in a program or activity in the United States. One of the places where we received a lot of questions about what might change under the new administration was with respect to training. So for example, we received a question. I believe that my biggest question is that we're in the middle of completing all of the trainings with the different categories of persons under the new Title IX regulations. Should we sign up and finish all the trainings, or stop completing the trainings, given that the requirements under Title IX will likely change under the new administration, especially considering right now Title IX is very procedural. So the short answer again is that yes, you do need to make sure that all of the Title IX team members at your educational institution have been trained. And again, we expect that we'll probably be living with these rules for some time, at least in some way, shape, or form. And so there really isn't any benefit to delaying on getting people trained. And so, as a reminder, what the regulations require is that you train all members of your Title IX team, which includes Title IX coordinators, investigators, decision makers on the complaint, decision makers on the appeal, and informal resolution facilitators on certain specific training requirements. And we at Franczek do have training options that are available if you don't have anything set up, but I would not wait in hopes that those requirements are going to go away. Only if and when we were to hear from the administration that that training is no longer required would we want to take a different approach. And again, even if the Biden administration were to come out and say, we aren't going to come after you through OCR for failure to comply with those training requirements, you could have a situation where a party goes to a court and says that this was a violation of these regulations. It's a violation of the law on the books, and it violated my due process rights is part of these proceedings. So we do recommend that you continue. We also had a question about training for staff, not the coordinators and the administrators, but the general staff. So what should we do for that type of training? And again, there's not any reason to delay, particularly if you are in a state like Illinois that requires training on sexual harassment for employees. So in Illinois, by the end of this year, by December 31st, you must have trained all employees on sexual harassment. And we highly recommend that you fold into that training on Title IX. And we do have many different types of options available for training. For all of our training options, we have live trainings, we have recorded trainings, we have the whole gamut. But what makes our trainings different is that they are focused to your institution. And so they really do make sure that they're covering what is necessary, not just the requirements under the law, but what is best in order to ensure to help mitigate any risk of non-compliance by your team members. So please contact me if I can provide you any more information on that. Our next question that we received dealt with the issue of conflicts of interest. And so this was a question from someone at a small K through 8 district where they only have three administrators. And so the question was, how do you divide up these different roles when you get an allegation, when the coordinator can't be the investigator and investigators can't be decision makers and the appellate decision maker can't be any of those people either? They have three administrators. How would you do that? Well, one thing to keep in mind is that although we at Franczek highly recommend that your Title IX coordinator not play any other role on your Title IX team, that's something that we recommend both because the Title IX coordinator has a lot of responsibilities under these new regulations. And also, we just are concerned about the perception of a conflict or bias if the Title IX coordinator serves their roles, their responsibilities in that role, and then turns around and serves as the investigator or the informal resolution facilitator or both. But that said, the rules do allow the Title IX coordinator to serve in those three roles. So the rules do allow the Title IX coordinator to serve as the Title IX coordinator and the investigator and the informal resolution facilitator. For most districts, we do not recommend that you do that. Same thing for higher education. I don't know of a higher education institution that has so few administrators that they would need to do that. But if your institution really is that small and really does need to do that, it is something that is possible to do. If you find yourself in a situation, however, where you have some type of conflict, a conflict that keeps, say, one person from serving as the Title IX coordinator, the investigator, and the informal resolution facilitator, the second person serving as the decision maker on the complaint, the third person serving as the decision maker on appeal. If that were to happen, you might look at a couple of things. First, you can always outsource. So our team, for instance, regularly is called on to serve in one or more of those roles for institutions for various reasons, including where there are conflicts of interest. And so potentially, for example, if there's an institutional conflict of interest, even at a very large educational institution, if for instance the complaint is against the star football player and there's a feeling that there's not going to be a fair shake when the school district is the state champions in football, they might come to us and say, we want you to handle all of these different roles. And that is a possibility. Also, there are consortiums that are popping up. So this is particularly the case in small K-8 districts and also community colleges, where we're seeing consortiums where individuals from one school may be doing roles for another school and vice versa, so that they are able to find outsiders, more people to staff their teams. The one thing I would recommend that you be very careful of there is to make sure that anyone who is in a consortium that you are a part of has gone through the same type of training and a consistency of training across those institutions, because you want to make sure that they are trained in the way that is appropriate for your institution. And if you need assistance with that, that's another thing we can help you with. So please don't hesitate to reach out to me on that. Our next questions or set of questions dealt with sharing of evidence. So we received quite a few questions about the investigation and the requirements that during the investigation that certain evidence be shared and that the investigative report be shared with the parties and they be given the 10-day time frame to respond. So the first of those questions was a question about, I would love to hear whether it is recommended that investigators record their witness interviews. Well, I'll tell you that there is not an answer. There's not a black or white rule as to whether or not you can or can't record investigative interviews. But there are a number of considerations you should take into mind before recording. First of all, you want to always make sure that you're considering your state's eavesdropping requirements, and you can usually get by that by notifying the parties to the conversation that they are being recorded and getting their consent to be recorded. However, even if that's allowed, you need to ask yourself whether you want to to record? Do you want to do so? And why might you not want to do so? Well, one reason is that when I've done investigations, both when I was at OCR and also when I do investigations for schools, colleges, and universities as an outside investigator, I don't like to record my interviews because I find that people are more likely to be forthright with me if they know they're not being recorded. It doesn't necessarily make sense because I can type really fast. I can type down almost everything being said verbatim and also be looking at you and having a conversation with you. That's just a habit after doing as many investigations as I have. So it's not as though I'm necessarily getting down less than I would be if I was recording. But for whatever reason, witnesses do tend to feel more comfortable when they know they're not being recorded. So that's one thing to consider. Another is the requirement that at the end of the investigation, before the investigative report is concluded, that the investigator must provide all directly related evidence collected as part of the investigation to the other parties, to the parties, to allow them to review it and to provide a written response. And the question is, even if you were to say to a witness, I'm really only taking this recording so that I could use it to make notes from later, or to verify my notes, and then I intend to get rid of it. Can you do that in light of the fact that we don't know if OCR would consider that to be directly related evidence? And so I certainly think it's less complicated just not to record. Now, what do you do if you have concerns that you aren't able to type down verbatim everything that's said? Well, have a second person who's there for your interviews who can take notes. And you can do that, ideally, I always recommend that you have two investigators on each investigation. If you have the personnel for it, that is the best case scenario because it gives you the ability to have one person there asking questions, another person taking notes, and that note taker investigator can jump in with questions or thoughts when they have them. But remember, even if you don't have the personnel for that administratively, that you don't have to have a note taker there who is a trained Title IX team member. You could have a note taker present who is an administrative staff member whose job is just to take the notes. And so that way you can focus on keeping eye contact, building rapport, doing all of these things that are such important parts of the investigation that can get lost in the shuffle if you're just staring at your keyboard the whole time trying to type everything down. The other questions we received dealt with the sharing of evidence that I mentioned. So one of the questions was, what steps can a school take to protect evidence from redisclosure from providing it when providing it to the parties for review? So remember, what is required is that you share all directly related evidence with the parties, not a summary, but the evidence itself. But we typically recommend that you do that in a way that will not allow it to be downloaded and saved. So there are a lot of programs, I won't go through them all, but there are lots of programs that allow Dropbox, Google, Office 365, all allow sharing things without giving the option to download it. So allowing people to view only. But of course, that's not going to stop someone from picking up their cell phone and taking photographs of the screen. So we recommend that you consider putting a watermark on each page that indicates whose copy is being shown. So it might say respondent, it might say complainant on the other one. And that way, obviously they can't keep people from taking the pictures, but if those were to get leaked out into the world, we would know whose copy had been shared. Other things to consider are putting passwords on the ability to share so that that person can't send out the link. You can also, a lot of times you'll be able to see when someone opens something using, when you've shared it with just that person, you, instead of sharing a link, you give access to just that person's email, and then it shows you when that person accesses it. Also considering putting a time frame on when it's available, so having it expire after a certain date. But I actually think that the most important thing is to make sure that the parties are aware, both verbally and in writing, that they aren't allowed to take photographs, that they aren't allowed to make copies, and that if they do, that that is a violation of your policies and procedures that can justify discipline. And that discipline doesn't require jumping through all of the hoops of Title IX sexual harassment complaints. We can discipline you pretty easily if you do that. And so I think getting the parties to sign off in writing that they acknowledge that they aren't allowed to make copies of or share that information and that they will be subject to discipline can go a long way to helping mitigate the risk of people sharing information with others. I've also received a few questions in the past week about whether or not schools are required to submit a draft of the investigative report to the parties. The rules don't envision that you share the investigative report. I don't read the investigative report as being part of that directly related evidence. So you are not required to provide a draft of the report. What you're required to do is provide all directly related evidence, give 10 days to respond before finalizing your report. And once you finalize your report, you must share that final report with the parties, and they must be given 10 days to respond before any decision, including if one is required for higher education, before any hearing. Our next question was a conflict with state law question. So the question was, how do we handle a situation where state law says you have to do one thing, but the regs say that you need to do something different? So in this case, it was a question about anonymous reports, where state law protects the anonymity of the reporter, but the regs want to require you to identify the complainant. Um, so I think the answer is pretty clear that the OCR has long taken the perspective that Title IX and federal law generally preempts any state law. So if there is a violation of state law that something in the rules would require, you are expected to follow the rules. That said, this is going to be a place where you're going to be wanting to work very closely with legal counsel that is very familiar with the ins and outs of Title IX, as well as the ins and outs of the state law that you're dealing with, so that you can make sure that you truly understand, am I required to do something that would violate one law? Because obviously we don't recommend that you violate the law. I will tell you that we have tried to find, and we've been able to find so far, knock on wood, ways to handle things under the regulations under Illinois law in a way that doesn't require violation of Illinois law. So hopefully, with some creative thinking and truly a deep understanding of the rules and laws in question, you'll be able to avoid that from happening. We received an interesting question about stalking, and the question was whether or not, if there is an alleged victim of stalking, but they are engaging with the stalker, would that meet the definition of stalking under Title IX sexual harassment? So if you recall, there are buckets of conduct that meet the due definition of Title IX sexual harassment, and that includes conduct that is part of the Clery and Violence Against Women Act Big Four. Those are stalking, domestic violence, dating violence, and sexual assault. And I put those in the wrong order. I usually say sexual assault, domestic violence, dating violence, and stalking. But so here our question is specifically about stalking. And you may know, if you're a reader of our blog, that we did do a recent blog post covering an OCR blog post where they gave us a little bit more clarification of how they define that those big four types of sexual misconduct. And with respect to stalking, as you can see from the definition here, what we're talking about is conduct of a sexual nature that would either cause a reasonable person to either fear for the person's safety or the safety of others, or suffers substantial emotional distress. So there is not, and I don't think there should be, a per se limitation on a finding of stalking just because, for example, the complainant might have friendly conversations with the respondent, or they might share interactions socially together. That wouldn't necessarily justify stalking behavior. What you're going to want to be looking at is whether a reasonable person in the similar situation who engaged the way that that complainant did with the respondent would have a reasonable fear for their safety or suffer substantial emotional distress. And I do think it's really important for people to remember that you need to have these definitions. You need to figure out how you're going to define those big four and make sure that they're in your administrative procedures at the very least. So, for example, the press administrative procedures, if you're an Illinois K through 8 school, those don't include the definitions that OCR set forth in their blog. And so you may want to consider revising those. And we actually have that off the shelf ready to go at Franczek. So make sure to reach out to me if you haven't thought through that, because you do need to make sure your community is aware of what definitions you are using. Our final question was how it was about retaliation, and how do you deal with an accused who threatens or files formal complaints against the accuser, alleging that the accuser's claim is based on lies for which they should be disciplined by the school? How do you distinguish that from intimidation or retaliation? And I'll tell you that one thing to really keep in mind is not to blow off that type of what we call a counterclaim. I saw that at OCR a few times, and it's not going to go over well under any administration. If a person has a counterclaim, you should address it. But how you address it can be impacted, number one, by whether or not the complaint is made in good faith. So if there's evidence that the complaint is just being made in bad faith and there's not really any support for it, and it seems as though it's harassing and retaliatory, there are steps you can take to protect the complainant, the original accuser, from that type of harassing behavior. But if it is a valid complaint, you should investigate it. And even if that means that that complainant has to go through what will uncertainly be a painful experience of having to be sort of accused, it feeling like it might be in retaliation, you need to make sure that if it is a good faith complaint, that you address it so that you don't inadvertently find yourself violating the rights of that original respondent by not addressing their counterclaim. All right, we are at the end of our time. Thank you so much for joining us today, and we really look forward to this each month. If there are any topics that you would like us to cover in the coming months, please reach out to me, and you can always reach us at Title IX at franczek.com. And thank you so much for joining us. Take care. We'll see you next month.